Why does everyone need a will? Hi, I'm estate planning and probate attorney Zach Beck with Peach State Wills and Trust, a division of the Beck Law Firm LLC here in Lawrenceville, Georgia, and we'll answer that question in today's video. We often run into people here that think they're in a situation where they don't need a will, but rarely is that the case. One of the most common situations we see where someone thinks they may not need a will is a married couple when they own everything jointly or have beneficiary designations on stuff, or just think that their spouse is going to get everything anyway when they pass. In that situation, you're still going to want a will for a couple of reasons. First, if you and your spouse have children and you don't have a will and not everything's owned jointly or has a beneficiary designation on it, your spouse doesn't get everything. Under Georgia law, the estate, that's the things that don't have beneficiary designations or joint owners, is split evenly between the spouse and living children, provided that the spouse gets no less than a third. So that means if you have kids, not everything will go to your spouse if you don't have a will. Second, a will is an only way to nominate a guardian for a minor child. While the other parent, if still living, would serve, you still want to have people named as potential backups so that if the other parent were to die before you, you have people you trust nominated to take that role, rather than leaving everything to the mercy of the probate court and other family members to step up and volunteer. A second situation we see where people think they may not need a will is when they have beneficiary designations on all their accounts or joint owners on all of their real estate. Again, here, this isn't the case. You still likely need a will. There's a non-zero probability that you die after all of the other joint owners and named beneficiaries. Then what happens? Do you have backups? If you don't, your things are still going to flow into your estate, and without a will, the state's rules are going to govern. Second, you likely have some quote-unquote stuff in your house, like the pictures on the wall behind me. Those things don't have beneficiary designations, and they don't have joint owners. Those are part of your probate estate, subject to division amongst your heirs. While you may think that your family won't fight over things, and that the people who want certain things in your house will just take them, and the stuff that's not wanted will get donated or sold, by not setting up a plan, by not providing any guidance as to where you want some of that stuff to go, you're setting up the possibility of a fight. We don't want that to happen to your family. Of course, we don't need to name beneficiaries for every possible thing that you have, but we want to make sure that people have an idea of what your plan is, so that son and daughter aren't fighting over the picture behind me. Because if they get into a fight and they can't resolve it, and it goes to court, no one gets half a picture. That picture gets sold, and no one's happy. No one gets what they wanted, and everyone's upset, and everyone's wasted time, energy, and money fighting when guidance given to them in advance could have prevented all of that. For more information about estate planning in Georgia, check us out online at peachstatewills.com, check out our YouTube channel, or give us a call at 678-344-5342.